Now I am going to dictate a legal passage based on Kolkata High Court judgments on matrimonial issues. Part 2 at the rate of 100 words per minute. Let's start. At the same time, it has to be kept in mind that a person cannot be compelled to undergo DNA test. Here, the petitioner himself voluntarily preferred to undergo DNA test. The question is, he has also prayed for DNA test of child Ritika since the divorce suit has been filed on the allegation of adultery. In my view, the learned court below ought to have allowed the said prayer of the petitioner para. In view of the above proposition of mental cruelty laid down by the apex court, we are of the view that refusal to grant divorce to the respondent or husband after continuous separation of the parties for last almost 20 years would lead to mental cruelty to the respondent or husband. In the background of acrimonious married life of the couple, particularly when there is no chance of reunion, I am unable to accede the submission of the learned counsel appearing for the petitioners that the subsequent decree declaring the matrimonial tie a void one on the ground of non-consummation of marriage would render the allegations of commission of offence punishable under section 498A of the Indian Penal Code odious. Stop para. Even though Section 19 was amended in the year 2003 incorporating the sub-clause within bracket small iiia in the said act to give benefit to a wife of the opposite party to come up with such a petition before the court concerned where she is residing on the date of the presentation of the petition, but this amendment cannot give a right to the present opposite party to file an application under section 25 of the said act before the district judge at Barasat, particularly when the original decree for divorce was passed by the civil judge within bracket senior division at Sambalpur. It is needless to mention that the substantive sections regarding divorce etc. are sections 9, 10, 11, 12, 13, 13A, 13B and 14. Section 25 or Section 27 is incidental in nature, deriving source from that original decree for divorce or etc. Stop para. Therefore, separation of mental illness, even if there be any, does not come within the mischief of section 420 of IPC. If parents of bride induce a complainant to marry their daughter, concealing the fact that the bride has some disease, no element of wrongful gain or loss to the property is involved, a bride cannot be equated with the term property. The basic thing is such that the offence under it consists of a dishonest disposition of property or valuable security within a square bracket. Also available at 2015 within bracket 3 CLJ within bracket Cal 604. Stop para. But in 2006, the Prohibition of Child Marriage Act was promulgated. Section 2 within bracket F defines a minor to mean a person who is deemed not to have attained majority under the Majority Act 1875. Section 12 deals with instances of a void marriage, but none of these instances is applicable to the instant case. On the contrary, it is section 3 which will be applicable, and such a child marriage is voidable at the option of the contracting party. Therefore, the marriage of Arman and Monisha is not a nullity in the eye of law, but is voidable at the option of the contracting party until one of such contracting party initiates a proceeding for annulment of the marriage. The marriage of a Mohammedan cannot be stopped. In the decision reported in AIR 2003 Supreme Court 2462, it has been laid down that the unfounded allegation by the husband assailing the moral character and chastity of the wife in his written statement amount to worst form of insult and cruelty sufficient by itself to pass a decree of divorce in favor of the wife. Stop. Thank you.